All right, before we go to our first call of the week, let's talk about our topic of the week, and that is, in the event that you're involved in an automobile accident, many folks who are injured in such accidents will get a lot of mail. And when they get that mail, it often comes in many different shapes and sizes. Sometimes you will get mail from your insurance company, the other guy's insurance company, liens from your hospital where you were in the hospital overnight, where you had a rather large bill. They will sometimes send you a lien in the mail. Usually they send those by certified mail. Sometimes you will get a letter from your own health insurance carrier, a sort of lien letter, and then you will often get a letter from attorneys that will either be providing you information, or they'll be providing you with a letter asking you whether or not you would like their assistance in this matter. It is very important that when you get mail after an accident that you pay attention to it. Pay attention to it very carefully. In some of the mail, for example, the mail that you will get from insurance companies, if you're getting a mail or letter from the insurance company for the driver who caused your accident, they will often be trying to solicit a recorded statement from you. And as I've said on this show over and over again, I don't advise giving a recorded statement to an insurance company without the assistance of a lawyer. Many times the insurance company for the guy who caused your accident will often be asking for an authorization. I am hesitant to advise you to sign that authorization without the assistance of a lawyer, because sometimes those authorizations are overly broad, invasive, invade your privacy to the extent that you should not allow them to, and so you need to be very careful about signing those authorizations with insurance companies. Even your own insurance company will send you an authorization, and sometimes what's called a no-fault application for no-fault benefits. If you fill those forms out correctly, then you're okay. But if you incomplete or don't do a complete form or incorrectly insert information in there, it could cause significant damage to your rights in your claim. And so I would be very careful about that particular type of mail, even with your own insurance company, and how it may damage your claim or case. If you get lien letters in the mail, those often occur when there are large medical bills incurred by an individual and not all of the medical bills were paid, or they were paid by a healthcare provider who thinks that they have a lien. Understand that not all healthcare providers have a legal right to a lien under Kansas law, so be very careful on what you agree to there as far as reimbursement with respect to your claim. And if you're getting liens, you really ought to talk to a lawyer. If you're getting lawyers' letters, I suggest, that you carefully look at those letters and see whether or not they are just a bald-faced solicitation of your case, or do they actually provide you with some information, some useful information that might be helpful to you in your case. Look at the letters, see where they came from. Are they a lawyer that you already know or know of? And most importantly, what type of information is included in this letter. If it's an informational piece, an informational letter that may actually provide you with useful information as to how to, say, negotiate the property damage on your claim, or what to do, what to say to a healthcare provider if it provides you some free information like that. That's one thing. And that may be something that you may want to consider responding to. If, on the other hand, the letter doesn't provide any useful information other than it asks you to call a particular number, and this is why you should call this number because we can help you, that to me is not the quality type of communication that you want to do anything with. It really comes down to whether or not the information that you get in the mail is going to hurt you or help you or be of no assistance to you. Be wary of all of the mail that you get where it could hurt you. There's a lot of that type of mail that if you respond to nonchalantly without thinking about your response, it could do significant damage to your claim. If you respond to it with precision, stating only the facts, stating what it is that happened in the accident, and as concise as you can, and you don't sign these blanket authorizations, and if you get a letter that seems to indicate something or somebody is overreaching, you need to consult with a lawyer and you will do all right. And that is our topic of the week.